The Contracts-Torts-PR crossover from July of 1999 is one of the most intimidating questions to appear on the California bar examination. As we will see, like all long, complicated questions with long, complicated calls of the question, this really is a little easier than it appears on first glance. Also, although this does have a lot of issues from torts, I do think this primarily is a contracts problem. But as we've already seen more than once, and we'll see again a number of times, civil remedies really is tested as one big subject. Torts, contracts, property, and remedies really are all one big subject. Still, the distinctions are useful, and we're going to see they are useful in answering this fact pattern too. Have a look with me at the elaborate and lengthy call of the question. 1. What theories, if any, might Westel reasonably assert against CODCO to establish and enforce the right to an exclusive license, and what is the likely outcome on each theory? Discuss. Well, it's pretty obvious that this is going to be a contract theory, but they're asking for more than one theory. So once we're done with contracts, we're sort of left scratching our head. Before we read the fact pattern, it's hard to think up another theory. But ones that come to mind could include theories out of torts, perhaps fraud, theories out of corporations, perhaps. We'll have to look carefully at the fact pattern and make an assessment. 2. Should Westel prevail in actions for tortious interference with the Westel CODCO contract against CODCO, Newcom, and Larry? Well, we know the theories of liability, and we're probably going to want to talk a little bit about a prayer for relief. But here, basically, we are being asked whether the plaintiff can establish a cause of action. And then, 3, what, if any, ethical duties has Larry breached? Discuss. Well, here's another flash forward to professional responsibility. Typically, PR questions are organized either around the duties or around the conduct. Since we're being asked about duties, we might think about the various fiduciary duties, basically the duty of loyalty and the duty of care, and consider what happens as we read the fact pattern. We may end up organizing around duties or around conduct, whichever is the easier way for us to organize as writers. Now let's have a look at this fact pattern from the top. It's pretty intimidating, but interesting. In paragraph 1, we meet Susan, someone who isn't mentioned in the call of the question. Susan is the chief operating officer of Westel, a telecommunications company. Felix is the CEO of Code Company, a software company. About a year ago, Susan and Felix negotiated and signed a valid written contract, under which Westel purchased from CODCO a license to use and sell software that prevents interception of telephone communications during transmission. Susan was assisted in her negotiations by Larry, an in-house attorney then employed by Westel. So Susan and Larry are on the same side. They are in the same company. And we also know that this contract is valid. So we're not going to be asked to go through all sorts of details about formation, defenses to formation, etc. We are told the contract is valid. But it gets a little more complicated in paragraph 2. Have a look at paragraph 2. Throughout the negotiations, Westel insisted that the license be an exclusive license for Westel to use and sell the software in the national cell phone market. The only language bearing on the subject in the contract stated that, quote, Westel shall have the use of the software. So the plain meaning of the language implies a non-exclusive license. Finally, in paragraph 2, we see the contract containing a clause stating that the written contract represents the entire agreement of the parties, an integration clause. So it looks as if no collateral discussions are going to be relevant to interpreting the content of this agreement. But read on. In paragraph 3, Susan is given oral assurances by Felix that the language would be interpreted as an exclusive language, and that CODCO would not license the software to others in the national cell phone market. Larry, Susan's lawyer at this point, advised Susan that he was satisfied with the oral assurances. Well, that conduct is going to come back to cause Larry some problems with the state bar. Next, have a look at paragraph 4. The following week, Susan sees an ad in the Trade Journal announcing that Newcom, a Westel competitor, is marketing a new national cell phone service using the same anti-interception software produced by CodeCo. She immediately called Felix to inquire about the Newcom ad and to remind him of the Westel exclusive license. Felix confirms that CodeCo had licensed the same software to Newcom and denied that Westel had an exclusive license. Okay, well, stop right there. Doesn't it look a little bit to you as if Felix has engaged in fraud? That'll be the second theory about getting an exclusive license. Go to the following paragraph. Here, Susan then calls Newcom and informs its CEO that Westel had an exclusive license and that if Newcom went forward, Westcom would sue Newcom. She was told that if she wanted to discuss it further, she should talk to Larry, Newcom's in-house lawyer, who had negotiated the Newcom CodeCo contract. Now we find Larry engaging in even worse misconduct. Next paragraph. It turns out that at the time Larry was assisting Susan with the Westel CodeCo negotiations, Newcom had contacted Larry and offered him a job. Newcom knew when it offered him the job that Larry was participating in the Westel CodeCo negotiations. That knowledge almost certainly is going to be enough to establish liability for tortious interference with contract. Larry quit Westel about 6 months ago and joined Newcom's legal staff. Finally, in the last paragraph, Susan confronted Larry and reminded him of his advice. Larry responded only with, "Well, you signed it." Okay, it looks as if we've got a conspiracy going on, but fortunately for us, criminal law and procedure has not crossed over into this fact pattern, along with seemingly almost every other subject on the bar. We get the call of the question again. Now, please turn the page and have a look at my outline of issues. Once again, we see that having a well-organized, thorough, analytical approach to these subjects makes outlining a good answer to a complicated fact pattern like this a lot easier. Superficially, take a look at the outline and see that it more or less follows the call of the question. I'm not reinventing the wheel here. But what I am doing here is filling in the spokes. Take a look at the first lawsuit between Westel and CodeCo. The basic theory of liability is contract. We are told that there are no formation problems, and I use that as a heading. Next, I indicate that Westel was bargaining for an exclusive license. I focus on the parole evidence rule and then remedies. Reformation, an equitable remedy that can be used to fix a contract, damages, specific performance, and I conclude that the plaintiff, Westel, wins a specific performance order against CodeCo under the facts in this case. Next, I focus on the fraud theory. We've got enough facts here to make this a reasonably substantial argument, but it isn't really as elaborate as the contract theory. Next, we turn on the tortious interference claims. Here, there are 3. Westel versus CodeCo, Westel versus Newcom, and Westel versus Larry. Here I focus on liability, and then I reach a conclusion. I don't really think there is reason to organize these arguments in more depth at the outlining stage. We've got plenty of facts to talk about. We will handle those facts. We will reach conclusions that make sense and that flow from our reasoning. Finally, Larry's many breaches of professional conduct. Here you're going to see that I organize around the duties. The duty of competence, the duty of loyalty, the duty of confidentiality. Then I use one fact as a heading, the apparent conspiracy between Larry and Felix. I think that one's worth its own paragraph, although certainly there are plenty of reasonable ways of organizing an answer to this PR section. One could do it just around the conduct. I think here it's a little more efficient and perhaps at least superficially a little bit more scholarly to organize around the duties. But here, there's plenty of room for reasonable people to differ. Okay, that's a wrap-up on an outline of issues. Now let's go through the answer briefly, and let me point out a few highlights. First, look at the very first paragraph in my answer. you'll notice I basically lead with the facts. I indicate that Westel will be able to pursue contracts and torts theories against CodeCo in order to establish and enforce its right to an exclusive license. So we focus on the contract theory. Notice under formation, I indicate what the facts are, that Susan and Felix negotiated and signed a valid agreement. That's literally the end of the story. There's nothing else to discuss with regard to formation. But then we focus on the exclusive license bargaining issue and the parole evidence rule. Certainly, the parole evidence rule is not designed to facilitate fraud, and applying it strictly to this case would have that effect. So we're going to throw the parole evidence rule out. We will affirm this agreement. Next, we turn to damages, and based on the facts that we've got, so far, Westel hasn't suffered quantifiable damages under a contract theory. Their preferred remedies are reformation and specific performance. Well, we've already covered reformation at this point, but let's now talk about specific performance. Here, given the complexity of this problem and the number of line items in the call of the question, I don't think it's necessary or appropriate to break specific performance down into its many elements and then go element by element. If you chose to do it that way and you had time to do it, there's no problem. As I say, reasonable people can differ substantially as to how they organize their answers. Still, you'll see internally in this paragraph, I do focus on the elements of specific performance, and I conclude that the plaintiff, Westel, will win specific performance. Next, I turn to the fraud theory, and here you'll see I have a couple of paragraphs that are quite dense with factual analysis. It looks as if we've got material misrepresentation, reliance. The bottom line here is CodeCo also should be able to win punitive damages in torts on top of the specific performance remedy that it's already won under its contracts theory. That's a very complicated lawsuit. Now we turn to tortious interference, and we have to handle several lawsuits in a fairly compressed space. Notice here, up front, I actually lead with a little bit of law. I define tortious interference, and then I get into the three lawsuits. First, Westel versus CodeCo. I don't think CodeCo is going to be liable for tortious interference because it is a party to the agreement. I think instead it will be ordered to specifically perform a reformed contract and also to pay compensatory and punitive damages based on the fraud theory. Next, we turn to Westel versus Newcom, and here there is plenty of indicia of bad faith on the part of Newcom. I focus on those details in the liability section, and I allude to them again in the conclusion. Newcom hired Larry away from Westel and obtained a license to software in violation of Westel's interests, and that's good enough for them to be on the hook for compensatory and punitive damages for tortious interference. Finally, we turn to Larry. The liability issue here is pretty evident. I more or less incorporate by reference in this analysis, but still, I do focus on the key fact. This guy, Larry, put his own personal interests ahead of his client's, and he actively worked to hurt his client. The bottom line is Larry's going to face civil liability to Westel for tortious interference, and that will include compensatory and punitive damages. Finally, we turn to Larry, and we've got plenty of time to hammer him for a while before we're done in our blue book. Notice how I lead with the facts. Larry was an in-house lawyer for Westel during the CodeCo negotiations. He's obligated to perform competently and to live up to the professional duties of loyalty, confidentiality. I focus first on his duty of competence. Here, you will see I focus clearly on the facts and how obviously Larry gave false and incompetent advice. Next, I focus on the duty of loyalty. I don't think we will see a more clear-cut case of a violation of the duty of loyalty anywhere in our work together. This guy, Larry, clearly was disloyal and incompetent, and then, for good measure, he violates the duty of confidentiality as well. And here, he is taking advantage of his insider knowledge of his client's affairs in order to get a better job and to benefit his new boss at the expense of his old boss. That's going to be good enough to subject him to liability in tort, as we've already finished discussing, and certainly it's going to subject him to professional discipline. So, finally, I conclude that Larry is in breach of his professional duties of competence, loyalty, and confidentiality. He's going to face civil liability, and he's going to face professional discipline. And that wraps up a very complicated and elaborate fact pattern. And if you didn't have a good idea about how to organize and consider all of these issues before you started to write, you were in pretty big trouble on this fact pattern. But on the other hand, if you had a clear analytical approach and a sophisticated understanding of how this material is tested, you would have a gigantic advantage against your competition.